Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2 of Jefferson County, Texas. You have been asked to come to court today for what is called an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is classified as a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious as a felony. If you have a felony case, felonies are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you had a state jail felony, the range of punishment would be anywhere from 6 months in the state jail to a maximum of 2 years in the state jail, and a fine up to $10,000. If you was convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years in the state penitentiary to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years in the state penitentiary to a maximum of 99 years to life and a fine up to $10,000. Now, if you're convicted of a capital murder, which is the highest felony, the range of punishment is either life or death. The case that you have here in this court is classified as a misdemeanor case. Misdemeanors are divided into 3 categories. You have the Class A, Class B, and a Class C. If you're convicted of a Class C misdemeanor, the range of punishment is a fine only. You cannot be given any jail time. You only can be given a fine. Now, your Class C misdemeanors are cases that normally originate or start in the JP court or the municipal court. It only comes up to this court when it is appealed. For example, if you're convicted in the JP court or the municipal court and you file an appeal, then it comes up to this court and the range of punishment is still the same. Fine only. We cannot give you any jail time. Now, if you are ordered to pay a fine, if you fail to pay the fine, then they can issue what is called a capious pro fine, where you would have to sit out the jail time to pay the fine. Now, if you have a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum 180 days, which is 6 months in the county jail. Or you could be given a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is 0 days to 365 days in the county jail, which is a year, or a fine up to from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. And that clipboard that you have been handed talks about your right to have an attorney. On the document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it states, as a defendant in a criminal case, you have 3 options to hire. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may waive your right to have an attorney or give up your right to have an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, Your case will be reset. Reset means you'll be given another court date to come back to give you time to hire your attorney. If you want an attorney and you do not have enough money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to have an attorney, that is, if you want to give up your right to have an attorney and represent yourself, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, when we say a written waiver, you are stating in writing that you have a right to have an attorney. However, you're giving up your right to have an attorney. You're waiving your right to have an attorney, and you are desiring to represent yourself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to request that an attorney be appointed to represent me, then you would have to place your initials on the third line to the left. If your choice is, if you have already been appointed an attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney or give up my right to an attorney and desiring to represent myself, if you want to represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then at the bottom of that document where it says defendant, you will sign your name on that line. And on the line next to it that says date, you will place today's date, January 24th of 2023, on that line. Now, if you are waiving your right to an attorney and you're representing and you're desiring to represent yourself, then you would have to read and sign the next page, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me, the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, if I have been advised this 24th day of January 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that is titled date, and today's date again is January 24th of 2023. Now, as a defendant in a criminal case, you have other rights. One other right that you have is the right to have a jury trial. That area over there where that young man is sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they will decide after listening to all the evidence whether or not you are guilty or not guilty. Now, you also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, you would not be having a trial by jury. However, your case will come before the court or the judge in one of three ways. One way it could come before the judge is by way of what we call a bench trial. A bench trial is a trial by judge only. The judge will listen to the evidence, and the judge will decide whether or not you're guilty or innocent after listening to all of the evidence. Another way your case will come before the court is by way of a plea bargain. It can come before the court by way of an agreed plea bargain. And what a plea bargain is, that is an agreement that you have worked out with the state to settle your case. Your case, if you have reached what we call an agreed plea bargain agreement, it will come before the court or the judge, and the judge will decide to follow or not follow the plea bargain agreement. Now, if you've reached a plea bargain agreement and the judge does not follow the agreement that you have reached with the state, then you can withdraw, which means you can take back your plea. So for example, let's say you entered a plea of guilty or no contest to the charges on the charges that you have. You have a plea bargain agreement. Let's say the state is offering you probation on a case, and the judge says, well, I'm not going to follow that agreement. Then you have a right to tell the judge, well, I withdraw or I take my plea back because you're not following our agreement. Okay. Now, the other way your case can come before the judge is by way of an unagreed plea bargain agreement. What that means is you and the state have not been able to reach an agreement concerning the punishment on your case. And so you want the judge to decide what the punishment will be in your case, okay? Now, if that happens, and if you decide within 30 days that you would like to appeal your case, you would like to have a higher court to look at your case because you think you've been wrongfully convicted or the court committed an error by convicting you, then you would have to get permission from the judge to appeal your case. The judge went along with the plea bargain agreement. If you want to get, if you would like to appeal your case, then you have to get permission from the court or the judge. Now, if the judge gives you permission, your case will go up to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will handle the appeal cases out of this court, and they will review your case. They will decide whether to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then at that point you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They're located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review. Now, pro se petition for discretionary review means that you will be filing this petition without an attorney. You'll be doing it on your own, and you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not you've been wrongfully convicted, whether or not this court committed an error by convicting you, or whether or not your appeal should have been granted. If they grant your pro se petition for discretionary review, they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then your petition for discretionary review, then at that point, your conviction will stand. Now, just to recap, you have a right to have an attorney. You can either hire an attorney, see if you qualify for a court-appointed attorney, if you do not have the money to pay for an attorney, or you can waive your right for an attorney and desire to represent yourself. If you desire to represent yourself, you can waive your right to have an attorney. The other right that you have a right to have a jury trial. That is, have 6 people decide whether or not you're guilty or not guilty. Or if you waive your right to jury trial, then your case will come before the judge in one of 3 ways: by way of a bench trial, by judge only, or by way of agreed plea bargain, or by way of an unagreed plea bargain. You also have a right to have witnesses to come to court. Witnesses sit in that chair right there. We call that the witness stand. They will listen to the evidence. Well, what witnesses do is witnesses testify, not listen to the evidence. They testify. They could testify either for you or against you. We call that, and then if you're representing yourself, or if you have an attorney, if you represent yourself, you can ask some questions, or if you have an attorney, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses to come to court. In essence, to give up your right. In essence, you have a right not to call witnesses in your case if you desire to do so. Now, if you do not call witnesses, or if you waive your right to have witnesses to come to court and testify on your behalf, that does not mean that the state will not be calling witnesses, because they will be calling witnesses to testify in the case against you. Now, you also have a right not to testify. We call that, you have a Fifth Amendment right against self-incrimination. I know sometimes we look at television, you see people say, "I'll take the fifth." And what that means is, I'm not saying anything. In essence, you have a right, a constitutional right, not to testify in your case if you desire to do so. That simply means that state of Texas, the government cannot force you to testify against yourself if you are exercising your right not to testify. Now, you can waive your right, your Fifth Amendment right against self-incrimination. And what that means is, if you waive your Fifth Amendment right against self-incrimination, you will be testifying in your case, okay? Now, you also have a right to have discovery. And what discovery means is, you have a right to see the evidence that the state has against you. So, for example, you have a right to see the documents, videos, witness statements, audio. You have right to get have access to audio recordings or any objects or instruments that the state has as evidence against you. You have a right to have access to that. Now, you also have a right to waive your right to discovery, which means you have a right to give up your right to have access to the evidence that the state has against you. Now, you're here today because you have been charged with a misdemeanor offense. You have been arrested, and you're out of jail on bond. Either you're out on a cash bond, which means you paid the full amount to get out, or you're out of jail on a surety bond, which means you paid a bondsman a portion of the bond, and you're out of jail on a surety bond, or you're out of jail on what is called a PR bond, a personal recognizance bond, which means you did not have to pay any money to get out of jail. You had a promise to appear in court under your own personal recognizance. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. If you spent 5 days in jail, and let's say the state district attorney's office is offering you 5 days of serving in jail as punishment, that simply means that you would not have to serve any more time in jail, because the 5 days that you spent in jail will be used as credit towards your punishment. So you'll be given credit for the 5 days that you have already served. Now, if the state is offering you, for example, 7 days in jail, and you serve 5 days, that means you have to serve 2 days in jail, because you're getting credit for the 5, okay? 5 from 7 leaves 2. Every day that you spent in jail also is credited as $100 that can go toward your fine and your court costs. So for example, using that same example, you spend 5 days in jail, that's $500 that can go towards your fine and court costs. So for example, if the state is offering you as punishment $500 fine plus, fine plus court costs of $500, so it's a total of $500, that means that you would not have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the $500 will be taxed and retired. You won't have to pay it. Now, if they're offering $700, if the fine and court costs of $700, that means you would have to pay $200 because you take $500 from the $700, that leaves $200. Now, you'll be required to pay the $200 on the day that you dispose of your case. Now, if you cannot pay it, let's say you're unemployed, you do not have income, you cannot pay it, then the court can convert the $200 fine and court costs to community service. So for example, every hour that you do in community service at a nonprofit organization, you will be credited $12.50 that will go towards your fine and court costs. So for example, if you work 8 hours of community service, that's $100. That's $12.50 times 8 is $100. Okay. So if you owe $200, that means you have to work 16 hours of community service. All right. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for people who have not been in trouble before. If you're a first-time offender, they have a program where they will dismiss your case and you can get it wiped off your record. We call it expunged from your record. Expunged means to wipe off, to erase, delete, or wipe off from your record, to get it off your record, off your criminal record. And the way it works is you have to have a lawyer, have an attorney to assist you at filling out the application that will be submitted to the Jefferson County District Attorney's Office, and it cannot be an offense. Your offense cannot be resisting arrest, unlawfully carrying a weapon, and as I said earlier, it has to be your first offense. So what will happen is you get in, if they accept you into the program, then they will dismiss the case. And once you complete the program, you can get it expunged, erased, deleted, or wiped off from your criminal history. All right. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. And Veterans Court is a program for veterans only. And it's part of the program, you complete the program, and then I think the case will be expunged from the record as well. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program designed to address what we call recidivism. Recidivism is when people commit crimes over and over. And so the way we address recidivism is through our CSI program. In that CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop is our local mental health center. We have individuals here from Spindletop. They'll come and talk to you in a few minutes. But what Spindletop will do, they will give you a private assessment, a private interview, do an assessment, and then they can develop a treatment plan, either outpatient or inpatient treatment for individuals who have mental health issues. Now, when I speak of mental health issues, I'm not talking about, you don't have to be insane or incompetent to be in this program. You could suffer from anxiety, depression, paranoia, schizophrenia, bipolar, anxiety, depression, and a whole host of other mental health issues. and Spindletop will be able to address them for you. If you have issues or problems with drugs and alcohol, Spindletop have a program that is called ATAR. And ATAR stands for Alcohol Treatment and Recovery Program. And also, our local Alcohol and Drug Abuse Council has a program that is called OSAR. OSAR, which is OSAR, stands for Outreach, Screening, Assessment, and Referral. Both of those programs are recovery programs. What they will do what is, you will have a screening, they can do an assessment, and they can develop a treatment plan, either outpatient or inpatient treatment, to address your alcohol or drug addictions. If you are unemployed and do not have a job, and you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of those areas that you select, they will assist you at getting employment in the area that you trained in. If you have not graduated from high school and you would like to get a GED, graduate equivalency diploma, then CICE also has a GED program. Now, all of these programs that I just mentioned to you, Spindletop program with the mental health, the ATAR, the OSAR program, the drug and alcohol treatment program, recovery program, the GED program, the job training and the job placement program through CICE, all of those programs are free. It does not cost you anything. Only thing that you have to do is have a desire to be in the program. And we have brochures and we have information we can give to you to assist you at getting in any one of those programs that you would like to get into. And also the program this pretrial diversion program, where you put it into the program and the case is dismissed. We also have information on that program as well, and also the program for the Veterans Court. Now, all of these programs that I've just mentioned through our CSI program, as I stated earlier, is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and raise our families. All of these programs are here in County Court at Law No. 2. These programs were started within the first 100 days of me taking office here back in March of 2017. I tell people this all the time: when you come to County Court at Law No. 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County, the county in which we live. All of these programs, as I stated earlier, we do not just arrest the problem, we address the problem. And we address the problem by not just giving time, but by taking our time. And we believe by taking our time, we can produce productive people. And we believe that if we produce productive people have too much to lose, and so therefore they will not commit crimes. And so this is the program that we have here in County Court at Law No. 2. If you're interested, just let us know, and we'll be happy to direct you in the area that you need to go to get the assistance that you need. Now, we have, as I mentioned earlier, we have individuals here. We have Wade, who's here with the Veterans Program. Wade is going to come before you and tell you a little bit about the Veterans Program here in Jefferson County. Wade?
Thank you. Good morning, everyone. As Judge said, my name is Wade Adair, veteran reporter with Spindletop Center, Texas Veterans Commission. So if you're a veteran assistance of any kind, to help you, I provide benefits and resources to veterans and yeah, so just let me know how I can help and be glad to. Thank you. Thank you.
Okay,
Thank you.
thank you, Wade. And now, ladies and gentlemen, we're gonna have Christian who's gonna come and tell you something about the Spindletop program that they have here, or the mental health program. She's gonna come and tell you something about that program. But in the meantime, the paperwork that you have that's been passed out, if you need any assistance at filling out that paperwork, we have personnel here in our court, that can help you or assist you with filling out that paperwork. Okay? Okay. So at this time, we have Danny. She's with Spindletop, and she's gonna tell you something about the Spindletop program. Danny?
Thank you. So with Spindletop, we try and help to the best of our abilities with anything with health issues, or just with any type of resources in general that you may need, whether it's housing, transportation. Like the judge said, we have ACAR, which helps with alcohol abuse and substance abuse. So what we try to do is come here today and let you guys know there is a resource out there for you. It's free. If it's not free, it's those by the income. So we try and help to the best of our abilities, those who want to be helped. So Spindletop not only helps with mental health disorders, it can if you're stressed about today, what's going on in your personal life at the moment. We also try and help and see what we can do for you guys to come back on it. The forms that we'd like you to fill out today, those are basic demographic forms, so it just shows what you may be needing help with, what you may be struggling with at the moment. If you choose to sign and say that you would like to talk to us, at the bottom, yes or no, you can read through that, also really quick, see what your stressors are, see what you may be needing at the moment. And if not, if you would just like us to call or text you another day, we can also do that. Talk to you, figure out what the resources that you're needing are, and help you to the best of our ability.
Okay. All right. Thank you, Danny. Now, ladies and gentlemen, now what we're going to do, we're going to give you a little bit more time to finish the paperwork, and then we're going to come by. We're going to have someone from the court come by and pick up that paperwork, make sure that it's filled out. And if you need any additional paperwork, for example, if a person says that they would like to see if they qualify for court-appointed attorney, then we have an affidavit of indigence that will be filled out, okay? And on that affidavit of indigence, basically, the information it'll have your name and your address. It also, and that has to be filled out, your phone number, and what if you receive any type of governmental benefits. For example, if you receive Medicaid, SSI, SNAP, TANF, or public, or you live in public housing, you would check the boxes that apply to you. If none of them apply, you just don't check it. If you are employed, you'll check yes. You state where you're employed, what type of work you do, the number of hours that you work per week, and how long you've worked at that job. If now the next line talks about your marital status. If you're single, married, divorced, separated, or widowed, then you will check off the box that is appropriate. If you're married, you'll name your spouse. You put that information, first name, middle initial, last name. Now, if you have any children that are 18 years old or younger, those dependents, then you'll write their name and their ages. And then when it asks for residence information, you state whether or not you rent, whether you own, a home, whether or not you reside with family members or whether or not you're homeless. At the bottom of that document, it states to the left, monthly income assets. Now, it only slash assets. Now, it's talking about your monthly income. So if you're making, if you're getting paid every week, then you have to figure out how much that is a month. Okay, so it's your monthly income. If you're getting paid every 2 weeks, then you have to, figure out what it is per month. Okay, and it actually now if you take home pay, if you're working, whatever amount you're making per month, you put it in that category. If you're not working, it's zero. If you have a spouse and your spouse is working, you put your spouse amount. If the spouse is not working, zero. If you don't have a spouse, it's zero. Now, if you receive child support, then you'll put how much you're receiving per month. If you receive SNAP, then you'll place how much you receive in SNAP each month. If you get Social Security / disability, you will write how much you receive Social Security disability. Now, if you do not receive anything, you're just gonna simply put zero. If you receive any type of other governmental checks, you write that amount that you receive per month. If you don't receive a governmental check, put zero. If other income, you'll place per month, you'll place that amount on that line. If you are not receiving any other income, it's zero. If you have assets such as a house, a car, etc., you'll place the value on the line next to where it says assets. If you do not have any assets, it's zero. And then once you get to the bottom, you're going to total everything that's in the column above, and then that will show your monthly income and assets. On the right side of that formula, at the bottom, it says monthly expenses. If you receive, if you're paying rent or a mortgage, you place the amount to the right. If you're not paying rent or mortgage, it's zero. If you have utilities, electric, gas, water, you're going to total that amount out. If you are not paying any utilities, it's zero. If you paying child support or any type of child expenses per month, you're going to add that up. If you're not, it's zero. Total food expenses, the amount that you're paying for yourself and dependents, you put that to the right. If you're not paying for food, it's zero. Transportation costs, and the transportation costs will be car note, car insurance, gas, your fuel, and any maintenance. You add that up, what that is per month. If you have a cell phone expense, you place that amount to the right. If you do not have one, it's zero. If you have probation fees or parole fees, you're going to place that amount to the right. If not, it's zero. Medical expenses or health insurance, you're going to place that monthly amount to the right. If you do not have a zero. Minimum monthly credit card payment, you'll place that amount to the right. If not, it's zero. And then you're going to add up where it says total monthly expenses, everything that is above in that column, you're going to add that up, and that'll be your monthly expenses. On the next page, it says defendant's oath. Now, you will read that oath. You will sign it today's date, the 24th of January of 2023. And at the bottom where it says, in that section where it says defendant's signature, you place your signature there and today's date. Now, where it says, the part that says unsworn declaration by defendant, that says defendant only, you will fill that information out, your name, your date of birth, social security, your address. And if you declare under the penalty of perjury that the foregoing is true and correct, you're going to say it's executed in Jefferson County, state of Texas, on the 24th day of January 2023. And then you will stop, and then the court will fill out the rest. All right. Now, as I stated earlier, if you need any help on assistance with filling out these forms, just let us know. We have court personnel who's here that will be ready to help. Yes. What did you say? Okay, we'll get somebody to help. All right. And so at this time, the court will be in recess so that you can take your time and fill out the forms and so that we can provide you with the assistance that you need. The court will be in recess.